Good morning. I'll call to order this February 13, 2020 continuance of the Seattle Waterfront LID assessment hearing. Today, objections will be heard for hearing examiner case numbers 97, we have starting now, 236 at 10:15, and then later today, case number 22 at 1:15. Just one procedural matter I want to address before we get started on case number 97. With the city, I've indicated your dates right now on the calendar being held are April 27, 28, 29, and 30. I would like to issue an order that generally carries a message of some notes on procedure, timing of when the city's going to go, cross-examination, et cetera, so that I can put that out for all of the objectors. Could the city please, I think our next time from today is on Tuesday, if the city could confirm that it's ready to go on the 27th and 28th, and they'd originally indicated they needed 2 days for hearing, if that's still the case, so we can on Tuesday firm up the dates that the city would be going.
Yes.
Thank you. All right, turning to case number 97, please state your name and spell it for the record.
William Justin, Justen.
And do you swear or affirm the testimony you provide in today's hearing will be the truth?
Yes.
Thank you. Please proceed.
Okay, Mr. Hearing Examiner, I brought you a binder to follow through with everything I've presented before and today,
All right.
with exhibits marked and so forth.
Okay.
That should be helpful. One question I had, have you had a chance to read the objection I filed on the February 3rd?
I have read every objection so far. Whether I can cite to it and remember specific
Right.
sections of it out of 400 plus objections is not likely, so
Okay.
you'll want to highlight specific sections if you want today as part of your testimony.
Thank you. Congratulations on that reading.
I'll have to do it again before the end.
Yeah.
So.
It's very complex. I'll introduce myself. Up on the screen is the information about our objection. We're the homeowners of the condominium unit stated above. We purchased our home when it was new in March of 2009. That was 11 years ago. My wife and I both have considerable real estate experience. Sandra's a real estate broker, and I am a licensed managing and designated real estate broker. Sandra's lived in the Pike Place Market neighborhood for 20 years and has been a listing or selling broker for more than 150 condominiums in 11 different condominium buildings in the LID for the past 12 years. I have lived in the Pike Place Market neighborhood since 1977. During those 43 years, I've been the developer and resident of the Pike and Virginia condominiums at 87 Virginia Street, Marketplace Tower office and condominiums at 2033 First Avenue at Lenora Street, and 1521 Second Avenue condominium tower. As a developer of these projects and dozens elsewhere in Seattle, I've hired and instructed many appraisers to prepare value appraisals for my projects. I've also am the former director of the City of Seattle's Department of Construction and Land Use, currently named the Seattle Department of Construction and Inspections. Actually, the department I ran also included the planning functions for the city. That's now been separated out into a separate office. I was also a founding board member and a faculty member of the Runstad Real Estate Center at the University of Washington. And in May of 2011, the Central Waterfront Committee appointed me as an advisor to the committee's Finance and Partnership Subcommittee to advise on the waterfront improvement strategic financing strategies. Just to make clear, my wife and I definitely support the improved, attractive waterfront. However, we are convinced that the Seattle will get that waterfront without any of the LID enhancements. I am disappointed that our request for a continuance for 90 days was rejected by the hearing examiner. We gave that request on January 22nd. The reasons were being that the 451-page studies that were done for the final special benefit proportionate assessment study that were dated November 18th were not made available until January 8th. And we are concerned why the city office of the Waterfront was attempting to place property owners at a disadvantage, as it did not give us, the owners in the LID, or our consultants, nearly enough time to study these comprehensive documents that are the basis of the proposed final assessment, which we received in the mail on January 2nd. We have submitted these objections and appeals, this letter to the hearing examiner, as our response to the proposed final assessment, which is being authorized by the Waterfront LID Formation Ordinance 125-760, passed in January of 2019. That's Exhibit A in this binder. I'd like to bring your attention to Section 5 and 6, and I quote those in our objection letter. Section 5 of that ordinance says the total estimated cost and expense of design and construction of the Central Waterfront Improvement Program is estimated to be approximately $712 million, notwithstanding the provisions of any other ordinance of the city. The total cost of the LID improvements, including planning, design, construction improvements, and B, the estimated cost of creation and administration of Waterfront, together the LID expenses and the estimated financing costs and the cost of issuing LID bonds, estimated amounts to be fund a deposit of the LID Guarantee Fund, is declared to be approximately $346.57 million. The ordinance goes on to say in this Section 5 that the portion of the LID expenses that shall be borne by and assessed against the property within the Waterfront LID specifically benefited by the LID improvements shall not exceed $160 million. It goes on to say assessments shall be made against the property within the Waterfront LID in accordance with the special benefits accruing to such property. Section 6 says under method of assessment, in accordance with the provisions of RCW 3544-047, the city may use any method or combination of methods to compute assessments that may be deemed to fairly reflect the special benefits to the properties being assessed. The ordinance is Attachment A, or Exhibit A. On the last page of that ordinance, there is a budget for the 6 items that are defined as the LID improvements, and I put a little tag on that for you. And I made some notes. Those 6 projects total $282.24 million. There's also 1% for the art and the administration by the city of $8.27 million for city staff to manage the project. Some other things that come to 48.3. So when I add those up, and the LID is 160 million, you can see and the total cost is 330. We can assume the LID assessments are covering 50% of each of the 6 programs that are proposed to be sponsored by the LID funding. So I will be using some of those numbers as I talk about each of those 6.
And Mr. Justin,
Yes.
I commend you on your organization. I was just about to tell you should have instructed some of your fellow objectors on how to do this. But did you make a copy of this for the city?
Yes.
And so the city has a copy?
Oh, I didn't. I'm talking to you, not the city. So I have my copy and your copy.
Right.
And
as part of this process, objectors are supposed to bring copies for the city so they can follow along.
I didn't see that in the instructions.
Yes.
It is 99.9% the same as what I submitted on February 3rd. The only difference is I added some exhibits and made reference to those exhibits. So if the city has the original filing, that would be substantially the same as what we're looking at today.
Was this chart of your,
Yes.
in your original objection in this form?
Yes, without my notes on it, though.
Without the notes, so
Yeah.
not in this form?
Right. But that was part of the ordinance that was in the exhibit.
But your
the
notes
filing.
were not?
Yeah.
Okay, and you're going to be referring to those notes and numbers?
I just did.
You also indicated that as you proceed, you're going to be referring back to
Oh,
these?
yes.
Okay.
What I'll be doing is reciting the number in the exhibit as the city prepared it and adding the 17% of other costs so that we can see the total cost per project.
Okay, here's what we're going to do. I do see, again, I do see you're very organized, and it's very helpful, and I appreciate that. But for key documents, we're going to need to make a copy for the city, and so that they can follow along with it. And that's going to delay us a little bit in time. You were delayed in some time because of the setup to begin with, so I'm going to make up time for you to do that. That was about 10 minutes. So unfortunately, we do have an objector coming after you, and we do need time for a break, so we will do that. But you're going to get the 10 minutes you lost with that. But I can't give you more time to make up for the fact that you didn't bring copies for the city. So you follow where we're going. I tell you that as a warning, simply so that as you go through your packet,
Right.
if there are areas that you want to trim up and maybe
Right.
make more efficient, you have an opportunity to do that, and I don't tell you at the end that you're out of time.
Okay.
But you can proceed, please.
Okay.
Are you going to be referring to this document immediately?
Um,
Go ahead.
Soon.
Okay, let's pause and get a copy for the city then.
Okay. Yeah, it is very minor changes related to the exhibits, which I was told I could bring more exhibits to the hearing.
Yes, objectors were asked to bring a copy for the examiner and a copy for the city
Okay.
when they were scheduled for this. And I understand individuals are not attorneys, and they're not used to all the instructions and how this goes. So we don't normally make copies as an example of how we're trying to accommodate this.
Okay.
So. While this document is being copied, are there any others that were not a part of your original objection that are original documents in here that are worth calling out and copying now, so I can just hand them to my assistant when he comes back?
Everything that is on the PowerPoint, there's 16 slides in Exhibit D.
So it'll
This
be on
binder.
the screen when you're
It'll be on
referring
the
to
screen.
it? Okay.
Yes.
Is there anything else that won't be? I'm just trying to identify anything else that should be copied at this time.
I don't think so.
Okay. Thank you.
So we're waiting?
Yes.
Okay.
If you want to give testimony about something other than the document that isn't referring to it, you could do that, but I'm holding this because the city needs an opportunity to have a copy of the document.
Right. So I could talk about something that is not in the documents.
That document, yes.
That document.
Mhm.
Okay.
I do assume that the city has access to your objection, and if they elect to bring it or not, that's up to them. But
Right.
if you bring a new item to be introduced today, and you're going to be referring to it, and it's unique,
Okay.
I need them to have a copy. So, looks like we made it through that part of the hearing, so
Okay.
please proceed.
Okay. So, our letter, I'm on page 3. In this letter, we'll explain our objections to the city's findings as they are clearly not consistent with ordinance section 5 and 6. And therefore, we object to any assessment for Seattle's Local Improvement District 6751, the LID, on our property at 1521 2nd Avenue for lack of any evidence, and going back to the ordinance, deemed to fairly reflect the special benefits to our property. And quoting the Washington Practice Instructions, special benefits are those that add value to the remaining property as distinguished from those arising incidentally and enjoyed by the public generally. So we're going to provide the following reasons and objections in sections A through L of this binder. First of all, our building is physically remote, both horizontally and vertically, from the central waterfront, as we're more than 3 city blocks, 1,240 feet from our building lobby entry to the promenade on the west side of Alaskan Way. Our building entrance is also 116 vertical feet above Alaskan Way. The waterfront is clearly not convenient to residents to take their dogs for a walk or to go for a stroll. The value of our homes, from a location perspective, comes from proximity to convenient shopping, services, and employment centers in the downtown core. Additional value for west-facing condominiums in our building comes from the views of Elliott Bay, but clearly not from proximity or close proximity to the waterfront. Let's see, the next slide, please. So our specific condominium home on the 29th floor is an east side of the building with a skyline view. You can see that there. Actually, that view is going to be lost when a proposed 46-story tower directly east across 2nd Avenue is built from us. And what irritates me is also that building that won't start construction at the end of this year would not be subject to the LID assessment for its improvements, and it's a substantially larger building than ours. And by the way, also, our building at 1521 2nd Avenue, I understand, has the highest special assessment of any single building in Seattle. And it's 11 years old. It's 40 stories, and now they're building 44-story buildings. They have built some 40-story buildings. There are much taller office buildings, hotel buildings. We are still assessed higher per our single building than any of the other buildings in the LID. We're not sure why that is, other than the assessor made huge mistakes. Let's see, the city's determination of final benefit value lift from the LID improvements of our home of $64,411.20 with a special assessment of $25,237.73 shows a complete lack of understanding of property values and general versus special benefits by the city's appraiser, even after the city spent millions of dollars in several years having studies prepared. We strongly object to the city's speculation that there will be any special benefits to our property. Therefore, the no special benefits enjoyed specifically by our property or the other properties physically remote by 100 to 150-foot steep bluff above the waterfront. All the planned improvements will be enjoyed by the general public, and that makes the waterfront a specific destination by the general public to enjoy the waterfront's general benefits. How am I doing on my time? Oh, there's the time? Okay. So that's the time of day. What
That's
time?
the time of, yes, the hearing started at 9:10.
Okay.
You were allotted 9 to 10, so you had an hour from 9 to 10.
Okay.
You lost 10 minutes because of the setup.
Right.
We're adding that, so
So
10:10.
I go to 10:10. Thank you. As structured, I'm on page 4. As structured, the LID is terribly flawed, as the LID enhancements are proposed to be paid for by existing properties as currently improved in the LID. However, there are hundreds of properties that will be developed and redeveloped in the near and distant future that will not be required to pay assessments based on those future improvements. Many of those are significant towers. This clearly inequitable treatment between existing properties developed to their potential and properties not yet developed to the highest and best use. There should be some kind of a latecomer's payment provision as occurs in other LIDs. I've attached in Exhibit C in the binder a quote from the 7-page letter from Anthony Gibbons on page 7, and it talks about special benefits, and I won't spend time reading that since that is public and it's in the binder and you've read it. On section C, page 5, upon our read of the before and after, no lid versus lid, in the addendum volume, pages A1 through A8, it's very clear to us that there will be no special benefit or value lift to our property from the LID funding for the following reasons. The lid before conditions describe major changes along the waterfront funded by public tax dollars. Will be great improvements over the previous waterfront conditions prior to the viaduct removal and Elliott Bay seawall project. These major changes, which clearly provide general benefits, as these changes will create attractive waterfront for the general public as a general benefit without the need for any LID funding enhancements. So I'm going to, let's see, next slide, please. This is a slide from the city's study. This is the promenade. It looks pretty cool. It's clearly a major roadway, 6 to 8 lanes, depending on where you are. This is the before picture. This has a lot of street trees, this has lighting, this has a boulevard down the center. This has a very wide promenade walkway that is open to handle a lot of tourists. This before picture from the city's, I quote from the city's study as to what is available before the LID. The viaduct's gone, the seawall project's done, the market front building project's complete, Pier 62 project will be complete, the multimodal terminal at Coleman Dock project will be complete, the Washington Boat Landing pergola will be complete, the Habitat Beach will be complete. On page 6, the rebuilt new surface roadway. In the LID before condition, new surface roadway would fulfill some of the functions that will no longer be provided by SR 99 after the Alaskan Way Viaduct is removed, by serving both local and regional transportation needs and providing access to SR 99, downtown and northwest Seattle. So what this is telling us is this is still a very major transportation route for the region. It's a truck route, it's got a lot of cars, and because serving downtown, you can't get into downtown from the tunnel. The tunnel exit and entrance is south and north of downtown, so this is still going to be a major roadway, not what the city has been selling us as a park. That is not a park and never will be a park. And we'll look at that picture a little bit more. The Moored roadway improvements before, again, I'm on middle of page 6, additional on-street parking and loading zones on the curbside on Alaskan Way, east and west side. A new arterial called Elliott Way would follow the path of the former viaduct to connect up the hill. 377 street trees planted in the median and planting strips on the east and west sides of Alaskan Way are part of the before, 377 trees. According to the LID, we add 16 more trees, and all the trees are a little bit larger. But that's a problem that I will show you momentarily. There's also the stormwater system being put in. Sidewalks on both sides of the roadway of Alaskan Way would be standard 2-foot by 2-foot scored concrete, which is the standard downtown. The LID would give you exposed aggregate, which is probably harder to maintain and gets dirty quicker than the city standard 2-foot by 2-foot scored concrete. There will also, in the before, be a 2-way bicycle facility, would run along the west side of Alaskan Way, begin at King Street and along Alaskan Way up to Virginia, and then later it joins over to the east side of the roadway to the existing bikeway. The Marion Street pedestrian bridge over Alaskan Way will be constructed. The reconnection of the Lenora Street pedestrian bridge to the new Elliott Way will be constructed. At the top of page 8, it mentions that there's accommodate 128 parking spaces. And I note that all this parking is lost if the after lid improvements are made, as it fills up much of the open space with trees and pathways. Let's look at slide number 8, the Overlook Walk. So we've got to jump ahead a little bit. This is the Overlook Walk, which is one of the major cost items, as I will mention a little later, the cost of that. What's interesting is it's a huge structure The market front that's been completed is here. You access this up here, come down, and I actually note that this is the bottom of the Pike Street hill climb. And the Overlook Walk ends up at the same place. So it's really not serving, it's very redundant, and it's a big, expensive structure, but I'll talk about that in a little bit. Let's see. That's the Overlook Walk. And I do note that in the city's description of the Overlook Walk, they mention the Pike Street hill climb, but they only mention that. They missed the other three existing pedestrian connections, Lenora Street, Union Street, and Harbor Steps at University. And I'll have a slide showing all of those existing connections, making the Overlook Walk completely redundant. The Pier 58 Park, nothing happens to that in the before. And I think it's a shame that the city has let that park, that's the only official park down on the waterfront, let that deteriorate, lack of maintenance and lack of upgrades over its several decades of existence. The following, I'm at near the bottom of page 8 on my section D. The following are our comments and objections to the 6 projects proposed using LID funding to enhance the major improvements that I've just described. And these are copied from the executive summary of the city special benefit study, pages 6 through 8. The 6 main, the first one is the promenade. So let's go back to the slide with the promenade. Slide 3. So there we see that, and we talked about the before already, the 377 trees, the stormwater, the bicycle pathways, and so forth. So the conclusion I have on this and is they have budgeted with the 17% addition to their estimated cost, with approximately half of the LID funding, almost $74 million for these enhancements. The more trees, the different walkway, and the bike additional pathways through the promenade. If we look at the next slide, slide 4, this is the after. So you can see the trees look a lot bigger. The road is still full of a lot of cars because it's still a roadway, which doesn't feel like a park. It's narrower on the west edge because they've basically created a tree canopy for the running and bike paths, walking and bike paths, and taken up some of that open space that way. To me, this is still a roadway, a 6 to 8 lane roadway. You can call it a boulevard, but let's look at the next slide. So this is from the city, and my concern is public safety. So I put a note there: poor visibility in the promenade from eyes on in the buildings East Alaskan Way, a major security concern for hidden risks to public and crime. So as a city planner and a resident of downtown for 43 years, eyes on the street is a fundamental public safety goal in comprehensive planning and zoning and so forth, seeing what's happening on your street. What this after is doing is basically creating blocks and blocks of hidden area. If we look at the next slide, the buildings on the right are not going to be able to see what's going on. And sure, it's fine during a July day with thousands and thousands of tourists, but when they're gone and the general public in a much reduced density is down there, this is going to be, I believe, like other parks, especially Freeway Park, where you really can't see. people around it. There's no visibility to kind of police it, to identify crime, to identify security problems. And I think this lush tree boulevard is a public safety hazard, and it is much better with the before option. If we look at the next slide, this is the Embarcadero, and my note down here says Seattle Waterfront best compared with the removed viaduct along the central waterfront with the 68-line roadway, and street trees, pedestrian sidewalks, retail piers, and waterfront views. So it's very much like the Embarcadero. The Embarcadero, I have a note up there, it's a little hard to read, but they have trees, they have several rows of trees, but they're spread out. They've maintained visibility, they've maintained eyes on the street from the buildings on the shore upland parcels. And I've spent a lot of time in the Embarcadero, and it feels perfectly safe because it's open, visible, sunny, and people can see into it at all times. Let's look at the next slide, the Overlook Walk. We saw that before, and my comments on the Overlook Walk on page 10. I'm saying this is totally unnecessary, redundant, wasteful of the city's estimated cost of $117.33 million. That's a lot of money. That's with the 17% add-on from the city's overhead and contingencies. It offers no new special general benefits because of the 3 nearby existing pedestrian connections between the Waterfront Pike Place Market. Let's look at the next slide. I think that's where it is. Yes. So on this slide, this is the before, so I'm calling this existing. So we have a pedestrian link here at Harbor Steps.
Mr. Justin, when you're describing this, if you could do your best to try and describe it to someone who cannot see you pointing,
okay,
would be helpful. Just because we're trying to create a record.
Okay.
And
so on this,
I'm following you just fine, but we're trying to create a record, and so
Thank you.
to the degree you can say east, west, the color red, or something
Okay.
visual,
So
descriptive is helpful.
this slide is the before slide. It shows some parking opportunities along the waterfront as well, but there are 4 black heavy lines going east-west, and the leftmost is Harbor Steps, which is a wonderful existing connection between First Avenue, where that line starts, down to the waterfront. The next one is the stair system on Union Street by the Four Seasons, and then west of Western. That stair could be improved, but it works. Use it every now and then. Then the next line is the Pike Hill Climb, and it goes through the market, which is a wonderful experience. Wide open stairs down to Western, and then the hill climb continues down from the waterfront. Then the 4th one is up in the far right corner, and that is the Lenora Street Bridge and elevator that connects the market area. And I talk about market area because officially the city designates the market south boundary of Union and north boundary of Lenora. So there are really 3 existing connections, as well as the Harbor Steps a block south of the market. So let's look at the next slide. So I also 1521 show that in the bottom center of where our building is, and that was on the previous slide. And there's a red arrow to the left of that. So the existing point of access from the market to the waterfront is basically a block from our building. The Overlook Walk is circuitous. It's further over to the right, and that's its entrance at the market front, so not as convenient. So let's go to the next slide. And this is the route from the city's drawings, and you can see the fuchsia color, I guess, which is the pedestrian route using the Overlook Walk. Our building is down near the bottom. I didn't add it onto the slide, but it's where it was before. It's near the route on the left where I identify that as the Pike Hill Climb and Overlook Walk they end at the same place. So for my building, it makes no sense to wander several blocks further northwest to get to the Overlook Walk if I'm going to the waterfront, rather than the direct route that I've been using for decades, which is delightful, through the market itself. So I'm saying that's redundant and has no special benefit to our building. Then Pioneer Square improvements. I think anything in Pioneer Square is a wonderful thing. I managed the Samus Land Company, and we had 14 or 15 buildings. We renovated those, like the Smith Tower and the Corona and the Terry Denny and the Collins Pub. Wonderful buildings down there. I managed that portfolio and did rehab those buildings over a 14-year period. However, the improvements down in Pioneer Square range from 10 to 14 blocks from my property. That really doesn't do any enhancement or special benefit. It's certainly a general benefit if I go down there like many people would through Pioneer Square, but certainly no special benefit to someone 10 to 14 blocks away. The Union Street connection, I just mentioned that on page 11. Another $16.3 million. It's a 3-block walk down First Avenue from my building. Has no value to my building because we have the existing, much more convenient Pike Street hill climb and Pike Street stair. The Pike Pine cityscape, that's a real big deal to us. Let's go to the slide 13. Okay, this is the existing Pike Street from 2nd Avenue. I took that picture because there was only a thumbnail picture I could find in the city's report. They had larger pictures of the others, but this is what it is today. And what's important to realize is our building is in the middle of the block to the right. You can see the State Hotel on the right, and we're immediately adjacent to that, just north on 2nd Avenue. Our garage uses that alley and exits onto Pike Street. Our alley serves our garage, which is 298 cars, let's call it 300. A 50-car parking lot that's heavily used by the market. The historic Doyle building has 30 cars that they park in their garage. There are 2 hotels that get services off of there. And our building alone gets 15,474 packages delivered last year and over 500 service vehicles using that alley. Now let's go to the after, what they want to do with it. The next slide. That's going to be tough to get access. And we can't go right, it's one way, so we have to go from the alley to the east to get onto 2nd Avenue or to continue on Pike. And this would cause a huge amount of value reduction in our property if we're restricted significantly for access to and from our building. Let's look at the next slide, please. This is Pine Street. So Pine Street is one way west, where Pike Street was one way east. This is the before, the existing, and the primary access to our garage, the parking lot. The Doyle building there on the left is the historic building that has 30 cars, subgrade parking, about 40 feet down the alley to the left. So this is the primary entrance to nearly 400 parking stalls and thousands of deliveries a year. We like it this way. It's got some nice trees. You can see the market sign down at the end, and you can see a little bit of the water as you get closer to First Avenue. Let's look at what the city wants to do. It's no longer going to be accessible in any reasonable fashion to get access, vehicle access into that alley. Left turn into the alley. Pine Street looking west. This is a disaster and would definitely harm the value of our properties if it is no longer convenient. Right now it's congested. This would basically block it and encourage pedestrians in the roadway, much like the market. And I go to the market almost every day since I lived there. And I always wonder why people bother driving a car down Pike Place in the market. This will have that kind of a feel, and we'll wonder, why would anyone drive down that? Well, that's the only way we can get to our building. So that is quite harmful to us, that proposal. And Pier 66 on page 12, I just mentioned that the existing waterfront park is part of a tourist destination of the central waterfront. It's tourist-oriented. It's got retail piers. The park itself is kind of a curious place for tourists to explore since it's recessed down close to the water rather than up at the sidewalk level. The city wants to spend $76.4 million, half of that ours. And I think it's a small park that's received little maintenance from the city, which is irresponsible. The described improvements reflect deferred maintenance of the park and lack appropriate improvements over the many years that should have been added to the park. On section E, I'm through the exhibits right now, I think, or the slideshow. From our experience, I'm speaking for my wife and myself, living in the Pike Place Market neighborhood for over 4 decades, including living adjacent to Westlake Park for 8 years and managing 15 historic buildings in Pioneer Square for 14 years, we've experienced the negative impacts to properties and pedestrians using or passing nearby public open spaces in the downtown core, including Victor Steinbrook Park, Westlake Park, Freeway Park, Occidental Park. These public places frequently attract unlawful behavior and threatening events. We all know that last week 7 pedestrians were shot 1 block from our building. We're concerned that the central waterfront boulevard, with even much fewer eyes on the street and on the pedestrian areas, even less than these other parks, because you don't have people living or working on the west side. That's the water, that's the piers. Even less than that is going to be a significant public safety problem for Seattle. I still have a little more time. Boy, I'm going faster than I thought. So I'll go to F. I'll just mention for 10 years I was the responsible official for the City of Seattle, lead agency on SEPA decisions and conditions for all privately sponsored developments. I read dozens and dozens of EISs because the city attorney at the time, Doug Jewett, made it clear to the mayor, Charlie Royer, that if he wanted to influence development decisions, he was going to have to come to the appeal hearings, and he said he wasn't going to do that. So I had to be the designated responsible official and had quite a bit of experience with SEPA as it, because of the one court case, decided that it no longer applied only to public projects but also to public decisions on private projects. Well, from what I can tell, I can't find any meaningful SEPA analysis of the Central Waterfront project. In G, I'm concerned about the budget. Everything is running way over. I'm working on projects right now in Seattle. Costs are escalating. Contractors say budget 3.5% escalation, but then when you get the bids, it's more like 8 or 9%. This $712 million project that the city's estimated we are going to go over budget. And how's that going to be paid for? Will the $100 and something million of philanthropy happen? If it does, the city's still short $80-some million. How's that going to impact the budget? If there are overruns, these funds would likely come from the city's general fund at the cost of general fund supported city functions such as police protection, support to the homeless, and social services. In H, I mentioned I have not focused much on the value of our home because my premise is there are no special benefits, so the assessed value is meaningless. But in H, I do say something that causes me some alarm about the credibility of the city's appraiser. In H, I say, as a further lack of confidence in the work done by the city's appraiser, the appraiser determined the value of our home, number 2901, on the northeast corner before the lid was $2,385,600, which tells us that the appraiser is completely unaware of the decline in condominium market values this past year in the LID. For example, the unit adjacent to ours, and I think this is a revised section from the earlier filing I did on the 3rd, because this happened after that. The unit adjacent to ours, 2902, it's on the same floor. We share a wall. On the southeast corner, sold for $1.8 million last week on February 4th. That's 15% less than the city's appraiser's before value of $2,074,800. Redfin, in January 2020 report, estimates our home at $1,971,000, which is 82.6% of the city appraiser's before value. My question is, if the city's appraiser is 15% or more, 15 to 18% off of market value, how can anyone believe his estimate of value lift of our home from a full LID improvements of 2.7%? When he's off 15%, how can he so scientifically come up with 2.7%? Well, he can't. And I think it's speculation, and I think this is an MIA appraisal, which means made as instructed. And I really think he was told what he had to come up with, because there's no document scientifically of an appraisal, as I have reviewed hundreds of appraisals over the years, that prove that this is correct. In conclusion, bottom page 13, as longtime residents and employees of downtown core and as active domestic and international travelers, where we've observed and studied public spaces, it is very clear to us that those major changes that are planned for the central waterfront in the before option without the LID enhancements will be a wonderful regional attraction, primarily as a tourist destination in the long summer days. This clearly will not be a neighborhood park, but rather a waterfront boulevard offering no special benefits and property value lift to property owners in the downtown core. Rather, our major concern is the large waterfront boulevard will be unpleasant and unsafe, as are other downtown pedestrian spaces during the dark days and evenings, which adversely impact our property values. Thank you for giving this very serious attention that it deserves.
Thank you, Mr. Justin. Anything further?
No, your copy has, we did a fresh signature on this and with the list of the updated exhibits, but I think I'm done.
All right.
Thank you.
Thank you. Your notebook will be entered as it is with as Exhibit 1 for your case number 97. Anything from the city?
Yes, thank you. Mr. Justin, are you a certified real estate appraiser?
No, I hire them and I advise them.
And do you have training or experience in mass appraisal techniques?
Yes.
Could you explain that, please?
I've studied extensively real estate programming, evaluation, cost method, income method, replacement method of appraisals, as I've studied appraisals for my projects. Worked with many of the appraisers in Seattle, and so I'm very familiar with the process of evaluation.
Have you ever prepared a valuation or appraisal?
No, I'm not an appraiser. It's not easy. It takes a lot of time to become an appraiser, but it's not very intellectually tough.
And are you familiar with the uniform standards of professional appraisal practice?
I can't quote them, but I'm somewhat familiar with them since I've hired appraisers over the years and discuss their limits of what they can and cannot do.
Thank you. Nothing further.
I'm sorry, Mr. Justin, I did have one clarifying question about one of your arguments. I believe it was it's in the slide that's up now. You indicated that the city's plans, you believe, will block access to your alley. Is that correct?
I would say impede.
And what specifically in the plan will do that? I'm looking at the image now, and I'm trying to compare it to the photo of what's there, now, and then I'm looking at the image of what is planned, and
This is what it is now.
right.
So right now, it's an open 2 lanes in order to go from Second and take a right, which is, if you're coming from the north, that's a frequent route, and then going half a block and turning left into the alley. Or another very frequent access point is coming west on Pine, crossing Second into this part of Pine and taking a left into the alley.
Understood. And then to the, if we can go back to the slide here, and what are what's your allegation of that? What is
It's
reducing the
narrowing it down to
value?
1 lane, and it's encouraging pedestrians to share the street, something
right.
like a Vornarf, like Pike Place in the market itself. This is going to make it much more restrictive in gaining vehicle access to go into this pedestrian auto mix area and taking a left into the alley with that number of vehicles that have to use it.
So it's the invitation of pedestrians into the right of way and reducing to 1 lane.
Yes.
Is that correct? Okay.
Yes.
Thank you very much.
Thank you.
We will adjourn. We will adjourn for a break and return at 10:15 for the next objection. We return to the record to hear case number 236. Appears the objector is not present. Common practice for the hearing examiner's office for all cases is to wait 10 minutes for a party. If they don't appear, then their matter is dismissed. Obviously, in this case, the objection would still stand for the record, but the opportunity to testify orally would be withdrawn. We will reconvene either at the appearance of the objector or at 10:25. Thank you. We reconvene to hear case number 236, noting that the objector is not present. The opportunity to testify in this matter is dismissed. The objection stands for the record as is, with no opportunity to supplement. We will reconvene for case number 22 at 1:15 today. Thank you. All right, I'll call to order this February 13, 2020 continuance for the Seattle Waterfront LID assessment hearing. We're now hearing case number 22, set for 1:15. Before I start with that, I see that Mr. Justin from our 9 a.m. hearing for case number 97 submitted a document.
For the city attorney, your copy.
Oh, that doesn't come through me. That just goes straight to them. All right, we've handled that.
Thank you.
Moving on to case number 22. Please state your name and spell it for the record.
My name is Eugene Burrus, EUGENE BURRUS.
And do you swear or affirm the testimony you provide in today's hearing will be the truth?
I do.
Great. Please proceed.
Thank you. I think we have, somehow I got assigned 2 case numbers as well, so I want to be sure we have that covered or something. I know in my notice it said 22 and 50.
The filing, the case number system in this is not exact.
Okay.
This is a unique hearing, and so it doesn't follow our case number system. I believe when we got started, some case numbers got assigned originally to if you filed, say, by email, and then something by hard copy, maybe to.
They got 2 assigned to.
We've got individuals who filed on behalf of 2 parcel numbers. We've got a whole thing, but
Okay.
trust me that we've got case numbers, we've got your parcel numbers. I know who you are.
Got it.
And you're in the system,
All
and it's
right.
all a consolidated hearing for purposes of that.
Good, thank you. I got 2 additional exhibits. I have a copy for you and a copy for you that you can either follow along on the hard copy, or one is the PowerPoint deck that I've got up on the screen here, and the other is a excise tax certificate from the King County Assessor's website that was not available yet when I was completing the deck, but became available today or yesterday. So.
All right, we'll mark the PowerPoint presentation as Exhibit 1 for case number 22 and the excise tax affidavit as Exhibit 2.
All right. So as I said, my name is Eugene Burris. My wife Lee and I are both retired, and we own a condominium within the Waterfront lid located at 1521 2nd Avenue, Unit 1702. We've lived there since we purchased that unit in 2012, and we were, prior to that, renters downtown. We've lived downtown for over a decade now. We've got a number of objections to the proposed final assessments, including the asserted market value of our condominium, which we believe exceeds the actual market value by more than 30%, and the 2.7% asserted special benefit, which we believe is unsupported and speculative at best. So first, unlike some of the other ones I've seen, we're going to address the market value issue first, and then move on to the special benefit analysis. But so we'll go to the market value first. So the initial appraised value without the lid assigned to our property is excessive and clearly not based on any examination of comparable sales and listings, nor any other credible evidence. The city appraiser asserts the market value of our condominium without the lid is $1,901,900. Comparable sales, which I will show you, prove that the city has overestimated the value of our property by more than 30%. Their guess doesn't reflect the realities of the market, seems to be unsupported by any evidence, and is an arbitrary and capricious value that the city appraisers applied without any examination, apparently, of comparable sales or understanding of the market or our building. So even if the arbitrary assertion of a 2.7% special benefit is upheld, we are being overassessed by approximately 30%. The city, okay, let's move on just to some of the basic math that we've got here. The city's assessor has determined his assertion of special benefit by assigning a special benefit percent change, and that value that he has assigned to our building is 2.7%. He asserts that percent change for every unit in our building as a positive 2.7%. Then he assigns a market value without lid to our unit and determines the alleged special benefit by multiplying that market value without lid by the 2.7% change. The proposed final lid assessment is then calculated by taking 39.18% of that calculated special benefit. Thus, that results in, because of the overvaluation of our unit's market value without the lid that exceeds 30%, that results in us being overassessed by 30%. So we live in a high-rise condominium that is 39 floors total. This is a picture of our building on 2nd Avenue between Pike and Pine, and roughly that's the view that we have, since our unit is in the O2 stack. Our unit is 1702, and the O2 stack is on the south and east corner of the building. All of the O2 units, at least up to the 29th floor, have identical floor plans, roughly identical finishes. The only differences you tend to see, even in finishes among units in the O2 stack, are coloration of countertops and maybe the colors of the floors, but roughly speaking, they are identical in terms of floor plan and finishes, and all have the same south and east facing view. It's differ only by the height above the street that they are. So basically, through the higher the floor, the higher the market value. But the comparable sales that I have are truly comparable, given that the only significant differences at all between units tends to be their height above the street. So there were two comparable sales. Sorry, this is old. There are now three. There were two comparable sales of the O2 stack during 2019, and then another last week on February 4th. The sales were Unit 1002, Unit 2702, and the amounts that they sold for and the dates that they sold for are here on this slide, which isn't showing up again for some reason, but you've got it. So-
I do have it.
Okay,
yes.
so, yeah.
And
so-
I'm actually following this more closely.
Good,
than that,
okay.
so.
So
I
then.
believe the city has a copy as well, so we all are on the
Okay.
literal same page.
So the next slide then, it has the comparable sales that have taken place within the last year in the O2 stack, which are our direct comparable sales. So Unit 1002 sold on June 28th for $1.25 million. That's 6 floors below ours. It's 6, not 7, because we apparently are superstitious and don't have a 13th floor. So 10 is 6 below 17, not 7. And then Unit 2702 sold for $1.8 million on October 16th, 2019. That's 10 floors above our unit. And then last week, 2902 also sold for $1.8 million, and that's 12 floors below our unit. The next slide has copies of the excise tax certificates for those sales that were downloaded from the King County Assessor's website. That shows the amount of the sales. So with these comparable sales during 2019, it's simply not possible that the value of our unit could be assessed at over $1.9 million in October of 2019. If you do the math, which I have on the next slide after the certificates, if you take the 2 sales that took place during 2019 and come up with a per floor differential for the valuation, you get what the calculation basically works out to. So take the $1.8 million that 2702 sold for, subtract from that the delta for what 1002 sold for, and you've got that's the delta basically that gives you a per floor. If you have, there are 16 floors between 1002 and 2702. And to get to the value for our unit, you take the sales price of 1002, which is $1.25 million, and add to that the 6/16ths of the delta between 1002 and 2702. That gets you to a market value of $1,456,250 for our unit located at 1702. The recently closed sale of 2902 that happened just in the last week suggests that there might be an even lower value for our unit 1702. And if you do the same math calculations based on that sale versus 1002, you get a value of $1,433,333. This delta is roughly a $35,000 per floor differential in market value, which is roughly in line with what the delta in sales have been throughout the time that we've lived in the building, and even from the time that we looked at units to purchase in that building. So it roughly is right and roughly in line with what you'd expect. So based on those comparable sales, actually our market value is overassessed by approximately $450,000. I'll note that the assessor's report claims that the primary focus of the residential portion of the valuation analysis is on the sales comparison approach. However, it's pretty clear that no comparable sales in our building, much less the directly comparable sales to our particular unit, were consulted at all when he arrived at a market value for our unit, and his conclusion is completely contradicted by the available information. To further demonstrate the arbitrary nature of the city appraiser's approach to assigning market values within our building, a quick look at the city's final report shows how arbitrary it is. So the following 2 slides I have taken from the final assessment report, the pages from the spreadsheet from the final assessment roll that cover our building, or cover at least the first 28 floors of our building. And what that shows is the city appraiser, though he claims to have stated that, quote, value adjustments were made based on an individual unit's floor placement. He says this at his final study at page 74. It's clearly not what he actually did, because if you look at the spreadsheet that he's got of values for units in our building, he assigns exactly the same $1,901,900 before lid assessed value to every unit in the O2 stack from I believe it's from 1502 all the way up to 2602. They all have exactly the same value assigned to them. So the assessor didn't actually do what he said he did in his report, which is to make value adjustments based upon an individual unit's floor placement. And throughout the history of the building, the history of the time we've lived in there, the history of time we've looked at units in other buildings downtown, there's never been a time when higher floors don't command higher prices. I'd like to also add that all of these sales took place before some rather unfortunate but noteworthy events took place downtown that undoubtedly will further depress downtown residential property values going forward. On January 22nd, during rush hour, a block from our home, another, and I say another because it's become a pretty regular occurrence downtown within a block or two of our apartment, another mass shooting occurred at the corner of 3rd and Pine, which is about a block from where we live. While shootings downtown, unfortunately, are not uncommon, this one actually made national and international news and will almost certainly cause property values for residential units downtown to drop further as people living here seek to leave and people that might have been interested in moving here are deterred. And the city's failures to properly perform its public safety duties are driving down our properties even further than the $450,000 that they're already below what the city asserts it's worth. By the way, if the city has a willing buyer at $1,901,000, I can close very fast. So the city has no evidence to support the assigned market value without lid for our property, none. Not a single comparable sale is cited or identified, and the methodology of equally valuing units in our building, despite big differences in the unit's floor placement, is clearly an error. The comparable sales prove that the city is inflating the value of our unit by over 30%. This further calls into question an appraiser and an appraisal that can get wrong the market value of our unit by more than 30%, but $450,000. It's implausible that his down to the penny assertion of a increase in special benefit of $50,000 could be held to be credible in any way. Nonetheless, let me get through that. So then if you do the math, just to close out this section of the argument, if you do the math then and reach a proper market value without lid for our unit of $1.45 million, even if you assume the appraiser's assertion of a 2.7% special benefit is valid, which we believe it's not, and I will be making a number of arguments why we think that's not valid, even if you accept that, the final lid assessment on our unit should be reduced from $20,120.57 to $15,388.97. Moving on to the arguments about the special benefit and the special benefit study itself. The final special benefit study is speculative or in violation of the law, I think, for a number of reasons and should be invalidated. First, the final benefit study violates the lid formation ordinance 125760 from January 19th, 2019, which requires plans and specifications to be on file with the city clerk's office, and from which the city clerk cannot significantly depart from. However, in response to, and that's from the formation ordinance, section 3, page 5, which reads, "The lid improvement shall be in accordance with plans and specifications prepared by the Director of the OWCP on behalf of the Director of Transportation of the Seattle Department of Transportation and on file in the city clerk's office, and may not be modified by the city council as long as such modifications, and may be modified by the city council as long as such modifications do not affect the purpose of the lit improvements or constitute materially different improvements. Provided, however, that changes in detail of such plans that do not significantly alter the scope or cost of the lid improvements will not require further approval. At the next slide, we have the city's response. Next two slides, we have city responses to interrogatories from the pending King County litigation. We have the city's response to interrogatory number 36 in that case, which asks the city to identify each person who participated in the preparation of the plans and specifications that are referred to in the following quote from Ordinance 125-760, Section 3, which is what I had just read to you. In that response, the city notes that no plans and specification as referenced in Section 3 of the ordinance are currently on file with the city clerk's office. The promenade is the only waterfront lit improvement that has reached 100% design that has complete plans and specifications. Those plans and specifications for the promenade have not yet been filed with the city clerk's office. And this response was dated January 17th, 2020. Next, in the city's response to interrogatory number 50, the city has admitted that design and construction of the waterfront lids improvements is a complex process that will take several years to complete, and that all the timelines for completion and all the designs, plans, agency reviews, specifications, and construction documents are still in process and subject to change. And this is from the city's response to interrogatory number 50 in that litigation dated January 23rd, 2020. If it's necessary, or if the city objects, I was trying to save trees and did not print out the entire discovery request. So if this is acceptable to the city, can we just admit these as direct evidence of what their responses were? So the final report actually acknowledges the speculative nature of these projects as well. The attempt, we've got the city's assessor himself acknowledges that currently the design process for the promenade portion of the improvements is 100% complete, just as the city's interrogatory response indicated. Design for Pier 58, which is formerly known as Waterfront Park improvements, is 30% complete. The Lower Union improvements design is 90+% complete, and design is 30% complete for the Overlook Walk portion of the project. The Pike Pine Corridor and Pioneer Square elements of the project have not yet reached the 30% design milestone. That's from the assessor's final report. So the attempt to impose a so-called final assessment role before there are plans and specifications on file with the city clerk's office as required by the formation ordinance itself, and while the projects themselves are not even design complete and subject to change, violates both the law and common sense. Attempting to attach precise, down-to-the-penny estimates of special benefits, while before anyone even knows what the waterfront lid projects will actually be, defines the word speculation and should invalidate the report and the final assessment. Second,
and let me stop you there and just ask you a question, Mr. Burrows.
Yes.
You may be making arguments in the alternative. I want to make sure I understand your arguments.
Yes.
On the one hand, you've indicated that the plans are not filed with the city clerk as you identify is in the ordinance.
Yes.
On the other hand, you've also are you stating, is that the basis for your challenge here, or are you also saying that without, even if this ordinance didn't exist, for example,
Yes.
That without designs and plans, there's not specificity?
I'm
Those are two
arguing
separate
both. I'm arguing
arguments.
both.
Okay, I just
Yes.
want to make sure I was following.
Yeah,
you.
definitely. Yeah, I'm arguing they can't move forward absent complying with their own ordinance. And then secondly, I'm arguing they can't move forward with a final assessment before designs are final, much less in the less than 30%
Okay,
range.
I
Yeah.
understand. And for the ordinance, you've got the section here that calls for the lit improvements to be in accordance with plans and specifications. Is there something elsewhere in the ordinance or in this section about tying the plans and the timing of that with the timing of the assessment? I mean, it says they have to be
Yes.
on file.
That's correct.
Is there some indication as to when that needs to be?
No, but I believe, not that I'm aware of, what I believe, though, is common sense would dictate you cannot move forward with a final assessment before you actually know what you're assessing. And we cannot know as a matter of law what we're assessing.
Which goes to your second argument.
That's right.
All right.
Yep. Okay. Next argument, I believe that the ABS report and the city's attempt to lump together the combined quote special benefit from 6 separate projects is actually invalid as a matter of law under RCW 35.43.050. That statute says where no finding is made by the legislative body as to the benefit of the improvements as a whole to all of the property within a local improvement district or utility local improvement district, the cost and expense of each continuous unit of the improvements shall be ascertained separately, as near as may be, and the assessment rate shall be computed on the basis of the cost and expense of each unit. In this case, there is, as far as I can tell, no such finding made by the legislative body, so that each project must be evaluated separately, and the special benefit or lack thereof to any particular property within the lid must be separately ascertained.
And I'm not sure if you've gone off script here or not. I don't see that RCW
So,
citation.
did I
in
miss,
your-
unless my printer screwed up? No, it's before that one, actually. There you go.
Got it.
Yeah.
Thank you.
So, that said, I think that's especially notable in this case, where only 1 or 2 of the 6 improvements that are being evaluated has even reached design completion or close to it, and thus would be subject to any reasonable study and evaluation. The city's failure to separately evaluate the 6 projects should invalidate the ABS study and the final assessment roll as a matter of law, I believe. Next, I want to get into why I think the completion of the waterfront lid remains speculative, because the funding for completing them remains speculative and doubtful at best. The city has acknowledged, based on what at this point are almost certainly outdated and understated budgets, that the waterfront lid projects will cost approximately $346.57 million. That's from the ordinance itself. On the unlikely assumption that there are no cost overruns or delays on these projects over the next 3 years, that means that completion of the waterfront lid projects will require at least an additional $186.57 million beyond the $160 million in capital lid assessments, which is capped by the ordinance as well. And then there's an additional amount for financing costs, but not to go to the capital construction costs. So we've got, at best, $160 million collected from lid assessments, leaving the city $186.57 million hole over the next 3 years that it's got to come up with. Currently, the city believes that they will obtain these additional resources from, quote, city, state, and philanthropic funds. I will note the last time we heard testimony in the city council about the collection of contingent philanthropic funds, they had raised approximately, they said, $20 to $25 million in philanthropic contributions towards the waterfront parks. So, however the city sources these funds, the city sources for this $186 million, less whatever they have committed from philanthropic, maybe 20 million, maybe a little more, we don't know for sure. They have not been secured or allocated by the city or by the city council. Whether these funds ever emerge is entirely speculative at this point. And these funds are essential to delivering the projects upon which the entire premise of delivering a special benefit to waterfront LID properties is based. If the city fails to complete LID projects on time and as designed and as analyzed by their assessor, the LID assessments have no legal basis and actually become illegal takings without due process. However, reliable sources for the funds have not yet been established. Whether or not they materialize is entirely speculation at this point. Indeed, the dependence on tens or hundreds of million dollars in philanthropy to complete what will become a legal obligation on the part of the city should render this LID and the final assessments invalid on their face unless and until the city actually secures such funds. The degree of the city's plan to depend upon unsecured private funding and donations is made clear in some of the documents that I linked to from my original filing that I made with you and the city clerk. The Central Waterfront Piers rehabilitation project is counting on $35.673 million in private funding, and the Overlook Walk and East-West Connections project is counting on $56.38 million in private funding. Currently, the city is promising LID property owners and the rest of the city, and representing to the hearing officer, that the waterfront LID projects and the supposed special benefits that they will bring with them will be completed by late 2023 or early 2024. Therefore, the city has 4 years in which to raise and efficiently spend at least $186.57 million. 2020 is already a lost cause in that regard from a budget perspective, because funding for, according to the city budget, funding for the Central Waterfront Improvement Fund was budgeted at $1 million for 2020, despite representations from the city that significant work would commence during 2020 on the new Alaskan Way and Park Promenade and east-west connections, including Union Street, Bell Street, Pioneer Square, and Pike and Pine. Incredibly, and adding to the speculative nature of these projects, despite promise of, never mind. Incredibly, and adding to the speculative nature of these projects, despite the city's promises by the city to begin construction during 2020 on east-west connections, including Pike Pine Corridor and Pioneer Square improvements, the city assessor's own report notes that design process for these elements have not yet even reached the 30% milestone. Yet we're expected to believe that these projects will be completed by 2023 and are expected to be able and we are expected to be able to meaningfully challenge and imagine special benefit that they will deliver, despite the designs being less than 30% complete. So, given that 2020 is already a lost cause with respect to the city budget on these projects, what we have in reality is that the city will essentially have 3 years, 2021, 2022, and 2023 budgets, in which to raise or secure approximately $185 million, assuming zero-cost overruns. Delay is not an option, downsizing it is not an option, and redesign is not an option. The city will legally owe every waterfront LID owner from which they took a LID assessment on these projects a completed, on-time, and as envisioned waterfront project. So that means over $60 million a year must be raised and allocated and spent effectively in each of the next 3 years. To understand the magnitude of that number, the project is currently budgeted for 2024 $1 million. And budgeted, and if you look at the entire parks building for the future budget for 2020 for projects committed to across the entire city, it's $33 million total. This will require an additional $60 million a year for the next 3 years plus. The city is legally committing itself to find sources for and to increase its budget by more than $60 million a year for the next 3 years to complete these projects on time and as envisioned. If that sounds impossible and improbable, I think it's because it is. The city cannot and should not be permitted to assess property owners on the ephemeral promise of delivering a special benefit when the source of that purported special benefit and its completion remains speculative at best. Until sources of funding emerge that can reasonably assure completion of the waterfront projects on time and as envisioned, These assessments are unlawful, premature, and speculative. Also, I'd say recent tragic events downtown further call into question the ability of the city to deliver the necessary $185 million or more over the next 3 years. The events on January 22nd, 2020, involving a multi-victim shooting, have led to necessary calls from the mayor's office and some in the city council to take steps to address longstanding failures of the city to address public safety issues downtown and crime and nuisances in general. This assertion of new priorities make less likely, not more likely, that the already impossible task of finding and allocating $185 million to complete this project will actually take place. The city simply has bigger priorities. I'll also add that I think we included in our original filing an opinion from the Washington Attorney General on the inability of prior councils to have legally bound future ones. So it makes the allocation of this $185 million more speculative yet, in that while they have to come up with it in order to give us the special benefit we've been promised, they are not legally bound to actually allocate the $185 million. So that makes the current attempt to assess and to make final the assessment rolls even more speculative. Next, I will move on to our particular property and why I think his assertion of 2.7% as an uptick for our special benefit is wrong and speculative and counter to all of the available evidence. So, our contention is the city appraiser's attribution of special benefit to my property and to that of residential properties in general, I believe, is arbitrary, is unprecedented in scope and distance, is counter to the realities of living in downtown Seattle, and is contrary to the academic literature on the topic. An examination of the 6 waterfront lid projects and the before and after conditions described show how ludicrous the assertion of the city's appraiser is, that my unit will somehow realize an increase in value of more than $50,000 and that any residential owner will actually realize any benefit at all. First, it's important, I think, to look at the academic literature that was relied upon by the city appraiser. It makes clear that the types of projects being undertaken are not the types that will add value to neighboring residential properties. To quote from the Crompton study, which is his primary academic article on which he relies, he says, "It's important to recognize that some types of parks are more desirable than others as places to live nearby. For example, there is convincing evidence that large, flat, open spaces, which are used for athletic activities and large social gatherings, are much less preferred than natural areas containing woods, hills, ponds, or marsh. Further, it must be recognized that there are contexts in which parks exert a negative image on property valued. A useful analogy is with a well-groomed front lawn, which is likely to increase the value of a home, but if it is overgrown with weeds, then the property value is likely to be diminished. This point was made directly by the Deputy Director of the Parks Council, a nonprofit advocacy organization in New York City, when she observed, "We have many poor neighborhoods in the South Bronx near parks, but the parks are not helping them. If you put money into a park, chances are that you will improve one portion of the neighborhood, but if the park does not have proper security and maintenance, it becomes a liability for nearby homes. Adverse impacts may result from nuisances, some intended, some not, such as congestion, street parking, litter, and vandalism, which may accompany an influx of people coming into a neighborhood to use a park. Noise and ball field lights intruding into adjacent residences, poorly maintained or blighted or derelict facilities, or undesirable groups congregating in the park engaging in morally offensive activities." We have a lot of that in downtown Seattle in public parks and public spaces, unfortunately. The academic literature also compares the impact on property values, on property values of 2 different kinds of parks, and I think it's important to look at that. That's a graph that I had in my original filing, but it shows increase in property value due to proximity of a park being positive for certain kinds of parks, but actually proximity being decreased due to proximity due to a highly developed park with nuisance factors. This park, as they call it, is in fact a highly developed park, which consists mostly of paved areas, that is actually designed to attract nuisance factors to downtown: crowds, tourists, noise, lights, that sort of thing, concerts. So it's actually the exact kind of park that the academic literature says decreases the value of adjacent residential properties. I'll then point you to some of the back to the slide deck that we've got, where we've got some pictures and diagrams of what is planned compared to what they attempt to compare it to. So slide 22 has a picture of the lit improvements and how they appear within downtown Seattle. And the lit improvements actually on that photo are just the orange slivers of pavement that are on that diagram. Nothing else, just the orange slivers of pavement. Compare that to the most comparable situation that the assessor compared it to for comparison purposes, to the Embarcadero in San Francisco, which is also primarily a thoroughfare for automobile traffic that was placed there after the destruction and tear down of a double-decker freeway on the waterfront in San Francisco. There you can see the Embarcadero after picture compared to the before picture, and then I've got another slide that shows both the before and after placed next to each other for emphasis. As the city assessors makes clear, the Embarcadero is what he calls a well-studied public benefit project. So well-studied that it actually destroys the assertions made by the assessor regarding the special benefits of the Seattle waterfront projects. As he clearly states, while the project is considered to have completely revitalized the waterfront area in San Francisco, there are no special benefits associated with the project beyond a 1 to 2 block radius east of the expressway. Now, that's for a project that, quote, completely revitalized the San Francisco waterfront. Compare that to the before and after of what the LID projects will do on the Seattle waterfront. And I know Mr. Justin showed you these slides earlier today, and I've got them in here again. But literally, the delta for the Seattle waterfront between pre-LID and post-LID consists of more trees and an aggregate sidewalk instead of a scored concrete sidewalk. I'll also add to this the city assertion consistent with the findings that there is no special benefit associated with the Embarcadero beyond a 1 to 2 block radius. Also from the Crompton study that is relied upon by ABS, he goes on to state that the area approximate impact of a park should be limited to 500 feet or 3 blocks. The empirical results suggest that this is likely to capture almost all of the premium from small neighborhood parks and a 75% of the premium from relatively large parks. The remaining 25% is likely to be dissipated over properties between 500 and 2,000 feet. Disregarding this will lead to an underestimate of the proximate impact of large parks, which may be substantial because while the premiums at these distances are relatively low, the number of properties within these parameters is relatively high. However, adopting this 500-foot parameter substantially simplifies the estimation task. Now, he's got our building at a 2.7% uptick for special benefit. That's what he asserts. That's near the top of his range for condominiums, which the top range for any condominium unit, he says, is 3%. He's got ours at 2.7, almost at the very top, despite our unit being well more than 500 feet away and over 1,200 feet away from all of the improvements, with the exception of the Pike Pine projects. So that assertion of 2.7% just isn't supported by the academic research that he relies upon himself. And unlike the Embarcadero, these waterfront projects are not in any way a complete revitalization of the Seattle waterfront. That revitalization actually took place by virtue of the destruction of the viaduct and the subsequent improvements, before lid improvements, that will be made to Alaskan Way along the waterfront. That's what's changed the waterfront, not the waterfront lid projects, which are at best incremental upgrades. It is clear that the appraiser's guess at special benefits are completely arbitrary and without basis. What is being constructed is not really a park at all, much less the kind of park with, quote, natural areas, including woods, hills, ponds, and marshes that could bring special benefits to adjacent residential properties. The only natural part of the Seattle waterfront is actually Elliott Bay itself, and that is definitely pre-existing. That definitely pre-exists the lid projects. Further, the city itself has engaged in a rampant mischaracterization in public of what the waterfront lid projects will bring. The mayor compared the waterfront lid projects to Stanley Park in Vancouver, which is a vast natural area covering over 1,000 acres. And then Marshall Foster, director of the Office of the Waterfront, also in a recent AAA magazine article compared it to Golden Gate Park in San Francisco, which is also an over 1,000 acre area with large open and natural areas. These characterizations are delusional at best, and they make as any examination of the intended projects here make clear. You can compare those parks to the tiny orange slivers that the Seattle waterfront lid projects actually entail, and it's not even close. I will add on the nuisance front, let's go. The before and after descriptions in the appraiser's report are actually striking for their revealed lack of significance. The pictures attached as exhibits and in this deck are even more striking and worth 1,000 words each. Starting at page 18, the assessor himself describes not really a park, much less one with the natural areas that would benefit adjacent residential properties, but instead describes what is primarily, quote, what is primarily more or slightly upgraded paving, lowered or eliminated curbs, and larger trees and landscaping. That's from his description of the after of the rebuilt new surface roadway and promenade. Then I've got slides showing the before and after for Union Street, the before and after for the Overlook Walk, which is described primarily as a paved stairway public space with landscaping. The Overlook Walk is intended to and provides access for pedestrians between the waterfront and downtown, and is either replacing or additive to existing access. I've got photos of all of those places that have existing access. It's redundant. At University Street, we have harbor steps with landscaping and fountains, and I've got a photo of the harbor steps access. At Pike Street, at Union Street, we have a staircase that leads down from the Four Seasons and past the public storage area, and I've got at Pike Street, we've got the Pike Street Hill Climb, which has elevators, landscaping, and lighting. At Lenora Street, we've got stairs and an elevator. And at Bell Street, we've got stairs, a bridge, and an elevator. The access aspect of the Overlook Walk is completely redundant and does not add anything for downtown residents accessing the waterfront. The Overlook views are also redundant, and I've got photos of that because the existing market front actually has the sweeping Overlook public view areas that the city would be being redundant and adding with the Overlook Walk. And I'll add, of course, that both the promenade and the Overlook Walk are several blocks from our condominium and far outside the 500-foot benefit range that the Crompton study suggests should be used. Next, we have the Union Street pedestrian connection, which would merely improve an existing stairway from Western Avenue to Alaskan Way. That is also several blocks away from my condominium. Pier 58 would become a, quote, flexible space that will facilitate events, performances, and activities along Elliott Bay. This is, again, per the Crompton study, the opposite of what would add value to adjacent residential properties. In addition, I'll say, the report notes the possibility of a public bathroom being added to the Pier 58, which the appraiser excludes from his lid analysis, but which would be an obvious detriment to neighboring properties given the realities and experience with public bathrooms that the city has had in its downtown areas and its unfortunate track record with regard to public restrooms. I'll also add that, like the other 5 of the 6 projects proposed under the waterfront lid, Pier 58 is also several blocks, more than 1,000 feet away from my condominium building. Notably, I'll add, the appraiser does not even attempt to describe at length in his report a before and after condition for the Pike Pine corridor improvements. He does briefly describe it in his cover letter, that both streets between First and Second Avenues will be reconstructed as, quote, shared space without curbs. Single travel lanes, westbound on Pine and eastbound on Pike, designed for slow vehicle movement and local access, will share the same space with pedestrians and bicycles. Bollards and detectable warning strips will help define the area to be used by vehicles, along with light poles, trees, and paving treatments. There will be more room available for sidewalk cafes. Other improvements will be made in the various blocks of Pike and Pine Streets between 2nd and 9th Avenues, such as planters, protecting bike lanes, etc., including construction of a new paved public plaza, a flexible space designed to accommodate diverse programming similar to Westlake Park on the south side of Pine Street between 3rd and 4th Avenues. The city's materials do have a couple of existing and proposed renderings of what we can expect from the Pike Pine corridor near my building, and I have attached, I include some of those in my slides as well. Pike Street between 1st and 2nd Avenues before, and Pine Street between 1st and 2nd Avenues before and after. And I think they make clear, this is, by the way, the only one of the 6 lid projects that is in any proximity to my condominium, and the appraiser doesn't even make an effort to justify or describe why those improvements would impact my unit positively, much less how they would justify any special benefit near the top of his range for condominiums. As can be seen from the renderings, the only significant changes that appear to be larger trees. It's actually unclear to me whether that is simply due to the time in which it will take to complete the projects and the growth of the trees that already exist there, or whether it means they will actually be planting larger trees, along with some repaving and nicer planters. It also appears they actually intend to remove the park space on Pine Street based on the rendering and incorporate that existing park space that exists outside the McDonald's on Pine Street there, and incorporate that into a wider sidewalk. The proposed changes to Pike and Pine, the only lid project anywhere near my building, would absolutely, I believe, reduce the value of our property. It would increase vehicle and pedestrian traffic nuisances. It will increase traffic. It reduces Pine Street westbound to 1 lane from 2, and will, as Mr. Justin said earlier this morning, greatly impede the ability of trucks to make the left turn into the alley, will unfortunately obviously slow the ability to even get to the alley in the first place, thanks to the 1 lane instead of 2, and will undoubtedly result in unfortunate encounters between pedestrians and trucks, I fear. It would also, as he said, we have over 15,000 package deliveries to our building in 2019 and over 500 service vehicle calls. One of the entrances to our parking garage is on the alley, and the loading bay for our building is on that alley. All trucks that need to make deliveries to our building have to use that alley, and it will obviously be slowed. Also, it will just impede, it will increase traffic for residents and will also impede our ability to get to that alley just as drivers as well. The project will make living in our building less attractive, not more attractive. The assertion of a 2.7% special benefit at the top of his range for condominiums should be rejected as arbitrary and capricious. The appraiser himself doesn't even try to suggest that the after for the only project anywhere near my building will have any benefit at all, and the literature on which he relies suggests that it will be a detriment rather than a benefit because of the nuisances that it's going to attract. Further, the literature upon which he relies shows a rapidly declining benefit with distance from parks, further discrediting his attempt to assess our building near the top of his range, despite our distance from the majority of the waterfront lid projects. I'll also add that his range for condominiums in general is also just as arbitrary. They're taken out of the air and apparently have no basis. Not only are these what is being proposed are not the type of parks that the academic literature says are preferred for residential properties, it's also the unfortunate reality that they are the exact kind of public space and facilities that the literature says can be a detriment to neighboring properties. The spaces are actually designed to attract crowds and visitors. That's great for businesses on the piers, that's great for businesses that cater to tourists in the Pike market area. It's not great for people that live there, and it's not great for the value of our property as we live there. Further, the reality of public spaces in downtown Seattle is that they do not, in fact, have proper security and maintenance and are a liability for nearby homes. They are plagued with litter and, unfortunately, needles and human waste, vandalism, and they're magnets for crime and drug use. Steinbrook Park, Westlake Park, Occidental Park, Freeway Park, and City Hall Park. These are all parks downtown. All are perceived by local residents as dangerous magnets for crime, drugs, and homelessness. Indeed, the situation at City Hall Park is so bad that the King County Courthouse recently had to close its 3rd Street entrance because even they were unable to provide for the safety of the public and their employees. Residents have no chance. Those of us that live near them affirmatively avoid walking through them or past them after hours and seldom, if ever, use them otherwise. Whether you consider those fears and reasonable or rational, that is the perception of downtown residents, and perception is what drives property values. The idea that a new area won't become this new park area won't become a dangerous magnet for drugs, crime, and homelessness defies the unfortunate reality that we have to live in every day. Even those parks like Westlake that are activated during the daytime and business hours, they are no-go zones for residents after hours. There is simply no basis to believe that this public space will be anything but a detriment for local residents and their property values, just as are the already existing downtown parks. That raises what I would like to propose for the hearing officer is that he actually, I know the rules provide for site visits. I would like to propose a site visit to both the waterfront, bringing the before and after pictures from the appraiser's report so that one can envision what the waterfront looks like, what it will look like before the lid, and then what it will look like after the lid, and its proximity and usability for various properties downtown. I would also like to propose a site visit. I'm not sure I'd want to go with you, but a site visit to all of the downtown parks after dark to understand how these impact the perception of living downtown. Tragically, the inability of the city to properly manage its role in providing for public safety and eliminating nuisances downtown, and the negative impact that those failings bring with them, was put on full display again on January 22nd when at the corner of 3rd and Pine, a multi-victim shootout took place, leading local, national, and international news and further cementing downtown Seattle's reputation nationally and internationally as a lawless, unsafe place to live. There is no evidence to suggest that the city will do anything differently downtown with these planned new public spaces. Further, the reaction of the mayor's office and the few city council members suggests strongly that budget priorities actually might change going forward to focus more on public safety and crime. We haven't seen evidence of that yet. They have simply reallocated some resources to the 3rd and Pike and Pine area, taking away from other priorities in the city, unfortunately. But their stated desire to increase budget and priorities with respect to public safety further calls into question what we discussed before, which is whether the city actually will be able to allocate the necessary $185 million or more over the next 3 years that will be required to deliver the promised special benefit. That said, if we go to the second to last slide, I'm actually close to done, so I'm not going to take all the time that I had. But I wanted to reiterate at least for the record, the timeline of some of the disclosures that have been made by the city in this case. I understand that you denied our request for a continuance on these motions, but I wanted to once again show you the timeline of disclosures made by the city, our opportunities to conduct discovery or lack thereof, and our opportunity to actually completely analyze and assess the final report. So the city actually mailed its notices of.
I did make a ruling on it.
Yes.
Normally I wouldn't allow that, but you're well ahead within your time, so please proceed.
Thank you. So on December 30th, and there have been new facts that have emerged since your denial of that too, which I will add to that. December 30th is the day that the city mailed its notices of proposed final assessments and notice of hearing. We received that notice on or about January 4th, 2020. I might not have checked my mail that day or the day before, but on or about January 4th. On or about January 8th is when the city made its final assessment report and addenda available. That's in excess of 400 pages of materials. I made my motion for continuance on January 10th and supplemented that on January 13th when I discovered that the final assessment report had actually been made available on the 8th. On January 13th, within 5 days of the city making its final assessment report available and disclosing the existence of supporting documents in the ABS appraiser's file, I made a public records request to the city clerk's office, to the Office of Finance, to which the letter was addressed. So that was done within 5 days. On January 15th, the city responded to that records request with an intent to begin production of documents on February 7th, 3 days after the intended hearing. On February 3rd, the finance office, the day before the scheduled hearing, the finance office made some of those responsive documents available by links. And on February 5th, the city ultimately made what they purport to be all of the supporting materials related to condominiums available by links from the city clerk's website. Still to come, as far as discovery goes, we have two other things. Just yesterday, we got from the city made available a copy of the extensive Excel spreadsheet that is contained within the final assessor's report in a way that we could actually analyze it. They made it available in Excel format rather than PDF format so that we could actually compare. I think that's important because it gives us actually the ability to go in and start to analyze some of what the assessor did, some of the arbitrary assignment of uptick in special benefit to even adjacent buildings with similar uses, and that was literally made available yesterday. Still to come, we have apparently the deposition of the city assessor, Robert McCauley, scheduled for February 27th or 28th. I'm not sure that date has been fixed yet. And then I understand there may be a motion to compel made for depositions of other city witnesses. So with all of that said, I'd like to leave the record open to perhaps be supplemented by either analysis of the Excel spreadsheet that I just received yesterday from the city, or additional information or facts that might come to light as a result of discovery from the city's witnesses.
Are you pausing for a response on that, or do you have more argument you want to present?
I'm done with my argument.
Okay, thank you. Before we go, if there's any questions to the city, I want to respond to a couple items that you asked of the hearing examiner. Again, this isn't question answer for the hearing examiner, but one is in the form of a question about a site visit. It's the practice of the hearing examiner from my predecessor, my mentor, for some time to always do site visits, and I being a walker, probably do it more than my predecessor. So, for example, in the Burke-Gilman Trail, which covered a large section of the city, I walked every block. I will walk every block in this case as well.
Good.
Of the Waterfront LID area. I have been in the vicinity of the parks that you've mentioned. At the hours you mentioned, I will decline to make some special extra
I
trip.
don't blame you.
But not for any other purpose than I believe I understand the issue already. The request has been made to leave the record open. The hearing examiner will note that the original motion was specifically directed at, and the order concerned very specific documents that were issued on specific dates. And so the order was indicating that for those documents, and let's look at the, so final assessment report, for example, they were available, recognizing the short timeline. I said, look, you've got time to do it, so take your time at that. There was one other objector that did indicate that they had made us a request for documents, and they weren't getting documents until after the date. That was a very different circumstance.
That was it was actually in my supplemented January 13th, I think.
See it.
Okay.
So, yeah, I don't see it here. I may have missed it, but there are 3 pages, so I'm not seeing any reference to the 7th. Regardless, I can leave the record open for that limited purpose for this. So documents that you are receiving in request to public records request, documents that are coming in during past the date of the hearing, in the course of the hearing, and you need to address those, you can do that by declaration and or submission of the documents.
Okay.
Do you have a sense of, I'll need to give you a deadline for that, though. We have had one other similar request from another party, and that deadline, if I'm recalling correctly, was April 13th. Purpose of that is to give the city an opportunity to analyze and review any new submissions you make. They're planning on putting their case on at this point. We're looking at April 27, 28. So.
April 13th would be sufficient to, I think, for us to get through at least analyzing the Excel spreadsheet and finding any other facts from that we
Okay.
might.
Yeah, let's recognize that the record's left open for the narrow purpose of addressing those documents you've requested, and you're just getting responses to.
And
now.
potential facts that emerge from the depositions of the city's witnesses as well, which are still upcoming.
I will not leave the record open for that. There's an opportunity to cross-examine the city witnesses later, and so that would be the appropriate timing for that, rather than doing it in a manner that the city can't respond to by objection.
Yep.
And so, recognizing you don't have documents in front of you, you need an opportunity to address those. I can't give you more time in the hearing. We're already going to be 30 days of hearing by the time this is over, but I can give you an opportunity to fill in or complete the record for your case with that. Okay?
Thank you.
I believe that addressed the questions you had of the hearing.
I think so.
examiner. Any questions from the city?
Just one question, and then just a comment on the outstanding documents. And Mr. Burris, it's true that this week that you closed out your public disclosure request to the city with respect to the documents referenced in Mr. McCauley's report?
Yes, that's true, because I got representation from you that all of the condominium-related documents were now available on the city clerk's website as of February 5th.
Right. The only thing I would say, Mr. Hearing Examiner, with respect to the production documents is we believe we did timely produce everything. The Excel spreadsheet that was produced yesterday is simply just searchable by parcel names. If one wants to type in Hilton, you can go around and see all the entries that say Hilton. But the experts retained by objectors or the objectors themselves have been able to do that by looking at the PDF copy for some time.
All right. Recognizing the challenge of navigating the electronic world, as it were, by objectors, and that the fact that they were given a date as opposed, and I don't, all I've been told by objectors is they were given a date from the city. What I haven't heard is we sent you the link. If that was the case, then I wouldn't have this problem. If the objectors didn't get the access they needed, leaving the record open for this narrow purpose on 2 cases at this point isn't impinging us in a already voluminous process.
Absolutely.
I believe we're completed then. Anything further from the city?
Nothing further.
All right, thank you, Ms. Burrows. We are adjourned for the day. We return Tuesday, February 18th at 9 a.m. Thank you.